But
So what's the remedy that you...
Sorry, go ahead.
I was just going to say that the examples you gave are pretty extreme to make your point. But it strikes me that your distinction between structural constitutional claims and the particular due process claims in the proceeding is going to be hard to draw in a large number of cases, particularly if you prevail and it makes a difference to when they can bring their constitutional or other challenges.
Well, with respect, Mr. Chief Justice, I don't know that that's the case. I mean, all we're asking for, as I stressed with Justice Kagan, is an application of the Thunder Basin factors. I think what we've been talking about really goes to the second factor about what it means to be wholly collateral. And I don't really think that's that difficult to apply in the due process context. If you think that the statute as set up just says, doesn't give you any witnesses, and that's going to be true in every single hearing, that seems like a case you ought to be able to...
Yeah, sure, but that's an easy case. I mean, anytime you get multi-factors, as in Thunder Basin, the application is going to be difficult in, I think, many cases.
I mean, look, there are going to be edge cases, to be sure, and I guess I would, this is where I would sort of remind you that the statutory text actually is pretty clear here, and if we're going to have a rule for the edge cases, I'd rather live in a republic where the rule for the edge cases was we err on the side of giving the citizen early access to the courts as opposed to erring on the side of deferring judicial review. I mean, the court could provide a different presumption, I suppose, to help with the edge cases, but I'd prefer it if it was a presumption that was in favor of judicial review. After all, Congress did pass 1331 that does seem to promise the people that if you have a problem with the constitutionality of government action, you can get early access to court to sort it out.